My name is Cary David. I'm a probate attorney with Florida Probate Law Group, and today we'll discuss summary probate administration in Florida. Summary probate administration is a simplified process that's faster and cheaper than the alternative, which is formal estate administration. The major difference between these two different types of probate is that in a formal probate administration, a personal representative is appointed to do business on behalf of the estate, while in a summary probate administration, a judge issues an order saying who gets what. In determining whether a case is eligible for summary probate administration, there's a few initial questions that we have to answer. First, do you need a personal representative for some reason? One example of why you might need a personal representative to do business on behalf of the estate is when there's a wrongful death case and a lawsuit needs to be filed in order to collect damages for someone's negligence that contributed to the decedent's passing. In a probate case with a related wrongful death case, you're always going to need a formal administration because that personal representative has to be appointed in order to bring the lawsuit. So, in a wrongful death related estate or any estate where you need a personal representative to do business on behalf of the estate, a summary administration is not going to be an appropriate option. Another question that we have to answer when determining eligibility for a summary probate administration is whether the decedent's family has all the information about their assets. In a summary administration, you have to be able to tell the court specific information about the assets that you're transferring, including bank account numbers and account balances for financial accounts. The reason you have to have this information for a summary administration is that the end result of the summary administration is the judge issuing an order that says who gets what. The family takes that order to the bank to receive their inheritance. But if the order does not state the account number and the account balance, the bank is not going to honor that court order. Therefore, if the family does not have all the asset information available, summary administration is not going to be an option in their case. The last question we have to answer for summary estate administration eligibility has to do with the total amount of assets in the estate. Summary administration is available in estates when there are less than $75,000 in non-exempt assets. What is an exempt asset? Exempt assets in Florida include the homestead property, which is the house the decedent lived in before they died, 2 vehicles, and up to $20,000 in household furnishings. Those exempt assets do not count against the total limit of $75,000 for a summary probate administration. One important note is that if it's been more than 2 years since the decedent passed away, the asset limit does not apply. So if you can identify all the assets, if someone has died more than 2 years ago, they're always going to be eligible for summary probate administration. When a case is eligible, summary probate administration is typically the best option for the family unless there's a specific need to have a personal representative appointed. Florida Probate Law Group has successfully handled hundreds of summary estate administrations all around the state of Florida. We work on a flat fee basis and take pride in delivering value for money. If you have questions about probate or specifically summary probate administration, give us a call at 352-354-2654 or go to our website for more information.